Good
morning, members. I call to order the meeting of the Bills Committee on Interception of Communications and Surveillance Amendment Bill 2015. For today's meeting, we are here to meet with Deputations and Administration. I just want to have a discussion with you. We have at first set aside 3 hours. But then we've only got 10 deputations or individuals who have put down their names to attend. But then one of them, in fact, the Law Society has told us that the representative cannot make it, so there are only 9. So I don't think we would be having such a long meeting as expected. I don't intend to have a discussion of other issues, so we'll listen to the deputations, we will exchange our views, and so probably we will call off the meeting earlier than scheduled. What do you think? No queries? All right. Well, in this case, it means that we can give more time to the deputations or individuals. Instead of 3 minutes, I would suggest that 4 minutes each. What do you think? Some have suggested 5 minutes, maybe 4. If we have further questions, I'm sure we can always have a discussion with the deputations. All right. Let's have it that way. And our secretariat have also invited the deputations as well as the administration to come in to join us. If I may explain, now in attendance we have Mrs. Millie Ng, PAS for Security, Ms. Mimi Lee, Deputy Secretary for Security, Ms. Alice Young, Assistant Secretary for Security, and from the Department of Justice, we have Mr. Godfrey Ken, Senior Assistant Solicitor General, and Ms. Monica Law, Senior Assistant Law Draftsman from the DFJ. Welcome, ladies and gentlemen. For deputations in attendance, I would like to welcome all of you for attending today's hearing. And this is about the Interception of Communications and Surveillance Ordinance. On this note, I would like to remind deputations and individuals that for this public hearing, you are not protected by the Legislative Council Powers and Privileges Ordinance as far as the exemptions and safeguards are concerned. So you need to be responsible for your remarks. Tabled before you, in front of you, you find a earpiece. You can tune in for channel 0 for the floor, channel 1 for Cantonese, channel 2 for English, and channel 3 for Putonghua. So if you need SI service, please tune in respectively. All right. Just now, I've already consulted our members. Instead of giving you 3 minutes each, having considered the fact that we don't actually have that many deputations of individuals, each of you will be given 4 minutes. And then members may want to put questions to you or explain their position. And then the administration will also get the views from you. All right, we are ready to listen to you. If I may just remind one thing for Ms. Yu, for the banner that you have with you, I think it's better for you to put aside your placard. Maybe you can show it when you're speaking. Miss Kenny Chung. Miss Chung. I'm just an ordinary Hong Kong citizen. I'm concerned about privacy and freedom of speech. In the past year in Hong Kong, there was the prevalence of white terror. Many Hong Kong citizens have lost faith in the Hong Kong government. You are worried that the law enforcement agencies would become the tools of the government. So I'm mainly about Part 4 of the ordinance. First of all, Section 39 says that the commissioner has been appointed by the CE for a term of 3 years, mainly monitoring the compliance with the ordinance on the part of the LEAs. The commissioner has a lot of powers overseeing 4 LEAs. What is most worrying is that the commissioner has been appointed by the CE. The CE may also remove the commissioner from office without any checks and balances. This is the first point. Second point is that under Section 44, mention has been made about the assessment. When it is found that it is not justified, then the subject should be informed, and then the subject may also ask for compensation. I don't know why the LEA's mistakes should be paid by the taxpayers as a whole, and I don't know why the government thinks that monetary compensation is most appropriate. I don't think so, because you may suffer psychologically. This may also give rise to undesirable consequences. And LEA may think that, may know that they are wrong, and at the end of the day, the penalty is merely a monetary compensation. There won't be any deterrent effect. And certainly, if it is found that the application is not in good faith, frivolous, or trivial, then the most that can be done is to reject the application. I have to point out that it is purely subjective. A person's knowledge about this matter can vary a lot. Say, for example, on a public occasion, Mr. C.Y. Leung, in relation to Leung Kwok Hong's aspiration for universal suffrage and universal retirement protection, he said that he couldn't hold back his lover, so his understanding is very different from the others. And we are purely relying on the subjective judgment of the commissioner. This is most disturbing. Fourthly, in Section 74, it is said that when the commissioner rules that there's non-compliance, the head of the LEA will be notified as to the action taken against the law-breaking officer. The most that has to be done is to ask for a report, and then I think it is unclear, it is absurd, and it is also a huge loophole. Even under the same set of circumstances, different heads of LEAs may suggest different disciplinary actions, maybe owing to the level or rank or position of the non-compliant officer. Should he be holding a more sensitive position or more senior position? Will he be subject to a less severe penalty? So the consequence may be unjust. And then for the case of the 7 police officers beating up a protester in a dark corner, so far we haven't got anything out of it. So we can imagine that there could be abuses. Now, the purpose or the objective of the ordinance is to make sure that we can oversee the LEAs. We have to make sure that the ordinance itself is effective. Thank you. Next, Ms. Wong Yuk-ting. I come here to talk about the Interception of Communications and Surveillance Ordinance. I've read the electoral brief, but I don't quite understand. And let me tell you what I think. I think it is quite like what has happened in a movie. That is, a citizen might have his communications intercepted and under surveillance because it's broken the law. So my assumption is that somebody must have broken the law before he is the subject of such surveillance. However, we've been using WhatsApp, Facebook, etc., among other social media when we surf the internet. Would this be subject to surveillance? And of course, I understand that reference has been made to public safety, but I think it is a bit vague. Let me assuming that during the umbrella movement last year. Somebody took part. He took a photograph, put it on a Facebook indicating that he was a participant. Afterwards, the government would like to settle the scores. The LEA would like to check the records. So I want to know if the LEA can get hold of the data and information posted on the internet. For that citizen, the citizen may think that it is against the law to have the movement, but then it is not a matter about public safety or public security. So the person involved might very well think that if he was participating in a very peaceful campaign, he was merely holding up an umbrella to withstand the tear gas, etc. In fact, on a particular day, it was rumored that bullets would be deployed. Luckily, this wasn't done because the umbrella could not withstand this one. So I want to know whether putting up an umbrella would already constitute an offense. All along, I've been talking about public security and also serious crime, but then it would only be subject to the assessment of one particular department. So to me, I think on the internet, we have been talking about the unjust acts of the LEAs, like the 7 police officers beating up a protester, and also in Mongkok, there were people bashing the heads of the police officers. So I want to know whether I've done some checking in within the Facebook, or if I have just had a chat with my friends. All this will constitute evidence of committing crime. Now, I think the rule of law is already the bottom line of Hong Kong. If there is a bill to be enacted, then it becomes our law books. But then, if there are areas of uncertainty, then I think the government should tell the taxpayers as to what will happen and how the law will be enforced when we have equality of everybody in front of the law. Here, I think we are most unsure. We don't know under what mechanism and how the judgment is to be made. Now, the government officials across the conference room may think that I have some misunderstanding. Now, as a taxpayer, I also pay towards your salary, and every month you are earning a salary more than 10 times mine. So please do not be lazy. And Ms. Wong, and if this becomes a part of our laws, then your future generation would also suffer.
Your speaker is given 4 minutes. When the time is up, I will ask you to stop, and I hope you observe this rule. Yes, next, Ms. Yuk-ting. Thank you. Good morning. I represent the Hong Kong In Media. The Hong Kong In Media has all along been paying attention to local press freedom, freedom of expression, and media policy. The ICSO has certain provisions which are similar to our concerns. We are concerned about the word communication. It includes postal service and telecommunication service. And we have observed that telecommunication service covers a very wide spectrum. Since 2006 until now, 9 or 10 years have elapsed. IT has been evolving all the time. When law was first enacted, it was just interception of telephone lines. We listened in, we eavesdropped on what you are speaking on the phone. And now the usual communication media are the WhatsApp, Telegram, Facebook, Google Hangout, emails, Gmails, which are all through the internet system, and they are covered under the definition of telecommunications. The ICSO should monitor the interception of communication by LEAs in this regard. But we don't understand why on the 9th of April meeting and also in the written reply of the Security Bureau, the administration did not admit that Internet service came under this law. And the commissioner, in his press conference, did not say that Internet communication or network communication is covered by this ordinance. Now, telecommunication does cover network communication, but the administration does not respond directly or directly admit that Internet communication is also part of telecommunications. Is the administration not sure about it, or the law is vague and not specific enough? And that's our concern. And we hope that the Bureau can address this point, whether Internet communication is covered by the definition of telecommunications. And Ms. Wong referred to public security. Now, the purpose of the bill, or the purpose of the ordinance, rather, is to uphold public safety and public security, in detecting serious crime, balancing that against personal privacy. When we ask the administration to respond privacy concerns, the administration resorts to the issue of public security to avoid answering the question. One example is that the definition of another issue is that the definition of violence is also a matter of concern. In 2006, the Secretary for Security said that surveillance, with regard to surveillance, the Secretary for Security said that it will not be used for political purpose, and I hope the government should address this point. Next is Ms. Chan Pek-Ti. Thank you. Good morning. I represent the Journalists Association. Now, the government proposed to move it. The amendment bill is to expand the power of the commissioner. But the amendment has not responded to the long-term concern of Journalists Association, which is the journalist sector, which is to protect journalistic material. In amending the law, the council should consider allowing journalist materials to be protected, just like LPP, so the journalist material will not be put under surveillance, thereby undermining people's right to know. Under the ICSO, it is said that the LEAs in applying for approval from the judges will have to provide information whether it is going to obtain any journalistic material. But in covert surveillance, it is very likely to obtain journalist material or has already obtained journalistic material, then such information is to be reported to the commissioner. If LEAs in doing interception has already obtained journalistic material, they have already obtained the information, and the information has been leaked. There is inadequate protection of journalistic material, and we have gone over the report of the commissioner. Since 2006 until December 2013, 7 LEA case of LEA officers intercepting journalistic material, and it has reflected that they are insensitive in making assessment on journalistic material. Protecting source of information is a very important element of obtaining journalistic material. We try to prevent the interception. I hope that journalistic material should be given the rights, or just like LPP in applying for interception. The LEA will have to conduct an assessment on the chance of obtaining journalistic material. And if there is any change to that assessment, then the LEA will have to make a report to the panel judges, so that the panel judges will decide whether the interception should be called off, or if it is allowed to continue, whether additional conditions will be imposed. As for journalistic material obtained before authorization, the material shouldn't be used and should be destroyed, to make sure that the communication between the journalists and the sources of information will not be undermined. As for authorization given to the commissioner to listen to the material, the amendment is positive. The commissioner is the gatekeeper. If the commissioner has given the power to get the raw material, raw information, then he has access to the journalistic material, and also he has information of the source. The commissioner, in exercising such powers, will have to make sure that the content is for examining whether the LEA has done its work properly, and the information should not be disclosed, and there should be adequate safeguards. Thank you, Ms. Chan. Next is Mr. Andrew Shum. The Hong Kong Civil Rights Observer finds the present amendment bill regrettable. The amendments are just patch-up measures. Major issues have not been dealt with. We have 5 points here. First, concerning reasonable expectation or legitimate expectation towards privacy. Under Section 2.2, anybody conducting activities in public places should not hold any legitimate expectation towards privacy. That means LEAs conducting covert surveillance on anybody conducting activities in public places will not be regulated by this law and will not need to get authorization from the panel judges. This is problematic. Covert surveillance in public places is a kind of infringement of privacy. In 2006, when this law was first enacted, the Bar Association and also Mr. Zhang Daming, a law professor, have also pointed out the issue. The covert surveillance in public places have always been criticized. This law only imposed very limited regulation on covert surveillance by LEAs in public on activities conducted in public places. There should be more regulation in this regard. There were 127 inquiries in the past with regard to the examination mechanism, and it's only that when there is no authorization that the applicant is appeal is, or rather application is upheld or approved. We ask the government to amend the law so that ordinary citizens, through the examination mechanism, know whether they have been the subject of interception or covert surveillance. The LEAs, in completing the task, should inform the subjects. As for abuse of power, the system itself has little deterrent on the law enforcement officers. If there are any non-compliance, then the law enforcement officers are just dealt with by internal disciplinary action. That is not strong enough. They are not deterred in breaking the rules. There is a need to criminalize the offenses under the ICSO, so that law enforcement officers will be held criminally, will have criminal culpability if they breach the law. Science and technology have progressed with leaps and bounds. It's not just eavesdropping anymore. As far as interception is concerned, I said that obtaining raw data should not be controlled by the law, but if under 2.6, any information in relation to communication by the telecommunication systems are covered, and any data arising from that communication are also covered under 2.6. So shouldn't the raw data be included as well? Next is Ms. Ng-wai Ling. Thank you, Chairman. Yes, I want to refer to the history of this law. Before this, there was this law. The former CE, Donald Tsang, issued an administrative order to authorize a law enforcement agency to do eavesdropping. Mr. Leung Kwok-hong applied for JR. The administration lost the lawsuits, and therefore the administration introduced this ICSO. But this very important piece of information is not available when introducing this bill. We find that the administration is not impartial. In studying the bill, members oppose the principle of various issues, and there were in fact 200 amendments made to the ICSO or ICS bill. With the support of the pro-establishment, all amendments were rejected. Lau Kong-wah, who was still the honorable member of this council, said that he stood there to block any of the amendments.
It shows that the administration was unreasonable, and also the pro-establishment camp was being very stubborn. When the ICSO was enacted, Justice Wu was the first commissioner. In his report, he has identified many defects of the ordinance, lack of cooperation of the LEOs. When the commissioner would like to examine the products, they were speedily destroyed out of uncooperation. And also, a lot of devices were involved in the interception of communications. But then the administration would not take on board the suggestions of the lawmakers. So I think we need to understand the background. The commissioner, the former commissioner, was most unhappy about the following. There is the recordings of communications intercepted were not available to the commissioner. So if the LEA is to be impartial, then the commissioner has no way to tell, and the commissioner cannot find out whether there has been instances of non-compliance. Now, on this regard, there is an attempt to amend the ordinance, and the commissioner will be given extra powers to listen to the protected products. I think it's right, but it's too late. We've got 3 points to make. First of all, lack of safeguards for the journalists. Currently, only LPP will be protected. But what about the fourth estate, the fourth power? The press will not be protected. So it is difficult for the press to enhance our right to know. And then I think we should remove the arrangement under which they cease to appoint the commissioner and the panel judges. I think the judiciary should be given the power to appoint members to the panel judges, to be panel judges. And certainly, should there be an authorized interception or going beyond the authorized duration, then the LEA officers should be made criminally liable if they have done so blatantly. Next, Mr. Chung-tet. Just like in the case of the hawker policies, under a lot of pressure, finally we see amendments to the ordinance. Justice Wu's proposals have been adopted, but then this is merely a fine-tuning because the mechanism is still plagued with a lot of loopholes. In the year 2009, Sid Ho, James To, and Leung Kwok Hong would like to seek amendments to the ordinance, but then it was met with opposition, like Chen Kim-po, Paul Chair, and other lawmakers. It has been said that the commissioner cannot catch up with the current position. I think we need to start with the inherent force in the ordinance. In fact, the Pan-Democrats sought to amend the bill in 200 areas, but then the Royalists unreasonably blocked all the amendments. Let me talk about some of the amendments back then. Without such amendments, we still have a lot of loopholes. First of all, definition of public security. You've ruled out protest and demonstration, but then it hasn't ruled out the reference to violence. Margaret Ng has asked for this to be focused on terrorism only, but then it was blocked. For those who have taken part in the umbrella movement, we know for ourselves that the police have got a very different definition for violence. Chili oil and the plastic wrap and umbrellas were still regarded as weapons of violence. And then in a civic protest, the police used a lot of devices to eavesdrop and intercept the communications, and they have been harassing the friends and family members of the protesters. But then in this bill, nothing has been made about ways to solve such problems. And then the definition of serious crime. I think currently the ordinance says that if the imprisonment term is no less than 3 years, then it will be regarded as serious crime, and then interception and surveillance will be justified. Well, I have to tell you that given such a definition, a lot of crimes will be regarded as serious crime. 7A of Public Order Ordinance, illegal building structures, dangerous driving. But I don't think you would want to be put under surveillance just because of dangerous driving or illegal structures. Now we are having a bill. Why don't we sort of go to the schedule of the Organized and Serious Crime Ordinance, where we have got a list of serious crime rather than merely drawing the line as no less than 3 years imprisonment. And then for unauthorized interception and surveillance, the LEA officers are at most subject to disciplinary action. Members have already criticized this. Mr. Li Xiugong, back then as the S4S, assured members that there was no need for extra penalty. He said that LEA officers should not be regarded as the rascals. But of course, nowadays the public have got a different view of the police force. In particular, they have been very professional in abusing their powers. They are professionally violent. And the commissioner has also mentioned the non-compliance on the part of the LEAs. So purely relying on internal disciplinary action would not be adequate. Thank you, Mr. Ng. Next, Mr. Loyo Kai. Thank you, Mr. Chairman. We have to point out that the scope of the ordinance is too narrow. There are lots of unclear definitions. We expect that there will be an amendment to make sure that there will be no interception and no surveillance for political motives, like including those surveillance actions in public places. And of course, currently the safeguards and protections of journalistic material is grossly inadequate. There should be the introduction of a mechanism to protect journalistic materials so that there will be something similar to the LPP. In addition, we haven't got a specific penalty for the offense of breaking the law. I think this is undesirable. For the non-compliance, there is for the unauthorized interception of communications and surveillance should be subject to criminal sanction. Otherwise, it would not be adequate. And then, what about LEAs from outside of Hong Kong? Mainland LEA officers can come and they are not bound. And what about interception carried out by private individuals? Unless they're breaking other laws, there's no way that they will be bound. In addition, I want to point out that given our political setup, one country, two systems is most sensitive. The government has promised that there would not be secretive political eavesdropping or surveillance. We have found that it is not just covert, but it is even very much in the public. So we cannot sort of prevent politically motivated surveillance or interception. I think we need a system to make sure that such will be brought under the system so that the judge, panel judges, the head of the LEAs will be able to stop politically motivated interception or surveillance. At the same time, we're quite clear about one point, that is currently the interception is basically done in such a way that the subject will not know it because this is being done secretly. So for you to expect people to apply for examination, I think the number is few and far, and only one was found in favor of the subject. No one has done this because they haven't been notified. Therefore, we need to identify the loopholes of the current law. The law already says that the commissioner should do the following. That is, the commissioner can only notify the applicant if he finds that doing so would not jeopardize the prevention or investigation into crime or the protection of public security. I want to know why there should be so many hurdles. I think all applicants should have been notified, and such a notification mechanism will make sure that the complaints can be lodged, and then the system will be subject to monitoring, and then those who are non-compliant will be deterred. So I think the provision is unnecessarily restrictive. It is most inappropriate to expect the subject to take the initiative to complain. Thank you, Mr. Law. All deputations and individuals in attendance have spoken. First of all, I'd like to invite members in attendance to indicate whether they have got any questions to ask or whether they want to share your observations with the deputations and individuals in attendance, and then I'll give the floor to the government for an overall reply. Mr. Charles Mock, Mr. Chen Kem Lam, Mr. James Toh, Mr. Dennis Kwok, who else? Mr. Sin Chung Kai, and Mr. Tony Chair would like to ask questions. And Mr. Ng Sing. Anybody else? No? Well, 5 minutes each. So I will stop you when you have used up your 5 minutes. Mr. Charles Mock. Thank you, Mr. Chairman. I'm grateful to have so many deputations and individuals sharing their observations with us. We have heard that a lot of problems are still unresolved. Let me say this. The ordinance will only bind the LEAs of the government. Now, I think for the movies that you have referred to, only the first in the serial is relevant. I think in the first part, there was an LEA officer, but for the second and third part of the serial, I think the protagonist was longer a government officer, so this shows how inadequate the ordinance is. And then Ms. Ng has said that we should also cover the communication on the internet. I haven't come across any applications or reports concerning the applications from the LEAs in relation to intercepting or overseeing the communications on the internet. I think they are interested in the raw data. It is quite unlike the telephone calls. So quite unlike the metadata, I think after your call has been completed, after communication has been completed, then the data to be obtained will be rendered into a data of a different nature. But allowing this to be done goes against the spirit of the ordinance. At the beginning of every year, I will ask the government to present some data to me for police. Between 2011 to 2014, we have got 3 to 4 such cases. And then I've also asked for the number of cases in which deletion has been applied for. We've seen an increase after the umbrella movement. For 3 years, there were only 90 plus cases, but then in 2014, September to February 2015, there were a lot of cases of deleting the information. I am afraid that the ordinance may not be actually about the kind of concerns that we have got in mind. Now, for such metadata, you may say that this is not related to the content of communication. But then we did put in a question. We asked for the number of cases in which a court order was available. We were told that you haven't got the figures. It is outrageous. You have got thousands or hundreds of such matter of deletion. But then how many court orders have been involved is easy to count, but they are not willing to provide the information. Do they have something to hide? And then for the point made by Mr. Andrew Shum, he referred to the metadata. He has referred to Section 6.2. I think any data arising from communication should also be included, like the metadata. I think Snowden's case is very sensational, all because of the metadata involved.
Concerning Mr. Sum's understanding, whether his understanding is right, apart from the content of communication, is metadata also included? Please answer the question. The Deputy Secretary. Concerning the question asked by Mr. Mock, in our recent reply, we've already provided some information. The LEAs in investing cases, because of crime prevention, because of the nature of the case, if need be, may have to obtain information for the investigation of crimes, and that includes obtaining information from ISPs locally and overseas, also information of the user name and also IP address, and also login records. We want to facilitate the collection of data, evidence, and suspects. Under the ICSO, the regulation is on covert activities of the LEAs, and in committing crime, they have to conduct such covert activities. If the LEA obtains information from an ISP or obtains a court order to collect data, then they are outside the scope of this ICSO. Well, that's by way of updating the background. I hope that the 5-minute rule can still be observed. This is the time also for putting your questions to the deputations. We have a lot of time to discuss with the officials. For further discussion with the officials at subsequent meetings. That will go on. Mr. Chen Kanley, I welcome the groups for coming to give their views on the ICSO. Your views are very clear. Notice that the Hong Kong Human Rights Monitor, the Civil Rights Observer have made several good points. I just want to make a point of view. Say the Human Rights Monitor is of the view that political activities should not be subject to interception of communication, and there are similar views by relevant groups. In upholding law and order in society, in preventing crime, in going after criminals, there's a need to conduct interception of communication and covert surveillance. Nobody is against it. You know, people are getting more and more extreme. That is blatant breach of the rule of law. It is getting more and more rampant. And even the legal sector, some people there encourage people to breach the law and then afterwards turn themselves up to the police. Liberalism is prevalent. That affects every aspect of our society. They bring serious threats to our society. If covert surveillance is not done on politicians or political activists, then law and order will be upset, and how can we balance that? We need to respect freedom and human rights. They are necessary. Are all people being put under covert surveillance? Don't exaggerate it to such an extent that everybody is subject to covert surveillance. This is not true.
守法嘅公民
If you are law-abiding, if you respect the overall core values, you will not be subject to covert surveillance or interception of communication. Well, when people refer to international standard, the international community has such and such practice. In all advanced democracies, how do they conduct these activities, say in the UK, in the US, France, Germany, Western European countries? How do they uphold law and order in society? How can they uphold national defense? How do they balance human rights vis-à-vis the needs of society? I don't ask the groups. I know their positions very clearly. And those in front of the TV who are looking into this broadcast may not be familiar with the provision of this ordinance, and therefore I hope the officials can explain that clearly. All right, please explain that succinctly. Yes, succinctly. Yes, we try to learn from overseas experience. Our present mechanism, if not being equal to the strength of overseas systems, we can say that we have exceeded the systems of some of the countries. Say for journalistic material, protection of journalistic material, Australia doesn't have any provision on this. In our law, in our code of practice, we have such provisions. So the regulation on COVID surveillance is stricter than other countries. Now, please make good use of the 5 minutes you have. I'd like to remind you that you better have more communication with the groups rather than discussing the matter with officials. But of course, I cannot stop you. Mr. James Toh, I want to put a question to the groups, or the deputations. Let's do it one by one. Concerning the scope of surveillance. In the past, technology was not so advanced. Then communication was mainly by letters. And then later there was telephone. And then if you speak on the phone, it just disappeared after you finish speaking, unless the telephone company records everything, or your counterparty of the communication records everything. But if you ask people nowadays, you seldom speak on the phone. You just send WhatsApps to your friends or your colleagues. WhatsApp is instantaneous communication, or line, or whatever. It's instantaneous communication. And there are groups. Say, NTICSO Alliance can form a group. Or NTICSA Alliance. Or there can be a group for dealing with Philippine hostages in Philippines. Now, legal advisor may supplement. Concerning the 0.01 second of communication, if you intercept it, that is called interception of communication, including intercepting WhatsApp communication. But if it's on the other side already, your ISP has kept a record, or my telephone has, my mobile phone has kept the record, then the police search the ISP. The warrant issue by the court will not be so demanding as the panel judges under the ICSO. So this piece of legislation is outdated. People don't talk on the line anymore. I don't believe the culprits do. Well, there are culprits, of course, who don't use WhatsApps. There are, of course. I don't know. But this ordinance is outdated, also for serious crime. Now, this instantaneous communication, if intercepted, in that 0.01 second is intercepted, then that is interception under the ICSO. But if you search the record from the ISP, then it is not interception, and therefore you don't need to resort on this high standard of regulation. So is there something wrong? That's my thinking. Maybe the groups can enlighten us on this. Mr. Law. Mr. Law. At least under the present definition, concerning the records reached the other party, they are not protected. The ISP may keep a record. The keeping of the record is simply for the purpose of communication or from the transmission. If you want to obtain a copy and then use it to conduct investigation, it is just the same as you intercept the transmission. Say if that WhatsApp, so the law should also protect this. If the WhatsApp has already reached me, if you want a warrant to check this, to search this, then you need a warrant. The administration doesn't want that. Anything of the kept by the ISPs should not be anything kept by the ISPs should also be subject to this ordinance. Then they should spell it out, and then if they want to obtain information, then they should get a warrant. Yes, my apologies, Monsieur. Yes, we are very concerned about this. What sort of information do the ISPs provide? What guidelines should the ISP follow in the provision of information to the law enforcement agencies? This is our concern, as said by other members. There are two parts. I sent a message. Can I continue? Yes, please go on. The first part, sending of the communication, is regulated by the ordinance, but when it reaches the ISP, then it is not regulated by the ICSO.
The ISPs, upon request by the LEAs to get the materials, have no grounds to reject. We are concerned about this. Dennis Kwok, if I may put in a brief remark. I think we need to invite the ISPs to come here to explain. Like after we've finished communicating, what about the data stored for WhatsApp and Line? And under what stringent criteria would ISPs allow the LEAs to examine the materials? I think they're experts. I think only they can tell us. I think we still have time to invite the administration to have a discussion with us. No, not discussion with the government. I'm sure we can pursue this matter later, but not now. Dennis Kwok and then Sin Chung Kai. Mr. Chan Kam Lam said that the legal profession has asked us to break the law and then surrender themselves. I don't know what it has to do with the ICSO. It is also not true. I'm not sure what he was saying. It was merely a wasting of our time. It doesn't matter. Let's come back to the bill. For the bill before us, indeed, we have identified many problems. As James has said, I'm also very concerned. When LEAs approach the ISPs, can they get hold of the metadata and other things? I think if it is done, then it is tantamount to interception of communications. Let me go back to the written submission of the Hong Kong Civil Rights Observer. I hope that the government can comment on these last two paragraphs of the written submission. Yes, Deputy Secretary. Thank you, Mr. Chairman. Well, the main point of the Civil Rights Observer is that metadata has been demanded. Section 6.2 says that any data related to the communication will also be included. Indeed, we are concerned about the interception of the content of the communication. Sorry, I can't hear you. Can you speak up? Move closer to the microphone. Well, what I was saying was that as far as the powers of the LEAs to demand the metadata, well, indeed, as far as this the ordinance is concerned, any data and the contents of any communication transmitted by a system includes any data produced in association with the communication. Now, when the LEAs combat crime, I think indeed there is some difference here. For the LEA to deal with crime, we'll look at the nature of the case, and if necessary, we will approach the relevant individuals or organizations for information, like the account data, and also the IP address, as well as the log records. Well, I understand indeed James To's worry is justified. Like say if I am using WhatsApp so as to exchange messages, it means that the LEAs may not be able to intercept my communication while it is being sent, but then afterwards they can approach the ISP or the relevant organization and try to get the metadata so as to reconstruct the message that I've sent out, say to whom I have communicated, with whom I've communicated, and what has been said. So I think this is the worry on the part of the civil rights observer and Mr. Law. Yes, indeed. The log record of our communication and also the metadata relevant to the communication will be obtained by the LEA. When we rely on the mail, then at that time it was very different because we didn't leave behind a trail. But currently, when we're using telecommunications, it seems that a lot of data will be available. I don't think there should be such a loophole so that they can get it afterwards and they don't need any authorization. And then it will not be subject to the judiciary or other independent mechanism. It should still be covered by warrant or it should be banned altogether. So it is clear that this kind of action or this kind of operation should be subject to the same kind of oversight, or they require a warrant as in the case of seizing all the evidence. Mr. Sin Chung Kai and then Mr. Paul Chair. Mr. Chairman, the ordinance has been in operation for quite a period of time. For the bill before us, I think this is mainly because of the recommendations of the former commissioner. However, I don't think it is comprehensive enough. This is because when we talk about interception of communications, well, in the process of transmission, that's the focus, but then this is quite a far cry from reality. Nowadays, we know that for the telecommunications service providers, we may be talking about the ISPs, but then there are also other service providers. We're also having other means of communication, not provided by ISPs, but a independent third-party service provider. Therefore, we need to elaborate on the definitions. Mr. James To has said that we should ask the experts to give evidence. I think it is right. They may not be interested in commenting on the bill, but we are interested in the process. And to be more specific, a lot of the service providers, despite having provided service to the residents and citizens of Hong Kong, the system may not be located in Hong Kong. And as you know that we have a lot of cloud computing technologies. The data may not be located in Hong Kong. So in the course of law enforcement, what sort of powers and what sort of responsibilities are involved. I think for this ordinance, we haven't got any particular provision concerning jurisdiction. So would it be like what Mr. Charles Mock has said, that is, we have to rely on the Interpol most of the time? Now, the bill will just be about minor refinements. We're still adhering to the existing sort of, we're still talking about the traditional modes of communications, like making telephone calls, etc. I think we're getting fewer and fewer of such. So I think we need to get more information from the service providers. As to the deputations submissions, as has been pointed out, safeguards for journalistic materials is an area that we should emphasize, but I think the bill hasn't addressed this point. So can the government comment on the following 2 points? There is challenges brought about by new technologies, and second, journalistic materials are going to consider the deputation's concern, that is to have it exempted. Mr. Chairman, just now I wasn't able to have time to supplement one point. Many of you are concerned about the demand for information from the service providers. Yes, it is not provided under this bill, but then IP address and log records have been requested from the service providers. But I have to clarify, it will not include non-open data. So if it is thought that somebody has been involved in crime, then a court order has to be applied for to get a warrant to seize the evidence. So it is quite different. Just now, Mr. James Toh said that, and other members have also said, whether we're going to narrow the scope of the ordinance. Members may want to know whether WhatsApp, WeChat, and other social media will be covered. Well, the ordinance has been designed in such a way that the act of interception, as far as any communication is concerned, it is about interception in the process, and it is not about the person sending or receiving the message. Under the Telecommunications Ordinance, Cap 106, there's a provision for the definition of telecommunication. So there is a definition that you can look up in that ordinance. So whether something is included or not, it all depends on the merits of the case, and then the panel judge has to find out whether it falls into the scope. For the concern about journalistic materials, of course, I have to say that when compared with other places like Australia, we have got more express provisions to safeguard JM. Mr. Tony Chair, I'm grateful to the many deputations individuals who have spoken. When we consider the ordinance and the bill, I think protection of public safety or public security, as well as the protection of privacy and human rights, I think the two should be balanced. We are all concerned about it, and it's important. Just now, in media has got a proposal, that is, we need to protect journalistic material. The government has already touched on this. I just wonder if Ms. Yu can further explain. For journalistic materials, how should we understand this term? And then, Ms. Yu, what is your suggestion concerning the protection of JM? Mr. Chairman, you know that everybody, many people are having smartphones. Many people would like to take photographs or videos of public activities. So you can easily find such materials on the internet. So, Ms. Yu, would you like to elaborate on your concern? Yes, Ms. Yu, for journalistic material, can you not sort of share your observations with us further? Thank you for your question. For journalistic material, of course, we have to go back to the Interpretation of General Clauses Ordinance that will give you an explanation about what is meant by JM. In the year 2012, it was found that some LEAs weren't too sure about the definition of journalistic materials. It was only after breaching. It's only after they have got an authorized interception, then they found that there was some JM involved. Well, for reporters to carry out their reporting work, they may have to come across anonymous sources to get information. So if the LEAs are not too sure about JMs and are not too sensitive to such matters, then we are worried that maybe in the future JMs may be intercepted. Well, in fact, our concern reflects on what the Commissioner has said. That is, it has been found that LEAs are not too sure about the scope that is allowed, and it seems that their training is inadequate. So, in the past, JM has been intercepted. It means that the LEAs may not be too clear as to what is allowed, and maybe LEAs haven't been given adequate training. So for JM, perhaps the Hong Kong JA can give you a more comprehensive answer.
Ms. Chen, could you help? Just now, Ms. Yu has raised this point. KWAN has a definition on journalist material. Journalist material is information obtained or prepared for the purpose, for journalistic purpose. If a person receives information from another place, and the person who collects information is for the purpose of dissemination of news, then that material is journalistic material. Chairman, I thank the two for giving me the view. Concerning journalistic material, refers to the material itself. As for who does it, that can be journalistic material. Say, for example, you use a mobile phone to take a photo. That photo may be journalistic material and can be covered in the definition. Or I think they also propose that to be included. Yes, the two have explained. With regard to journalistic material, that is a clear definition in Cap 1. And Ms. Yu also has referred to that. As for interpreting that, it is not about the material itself, but about the source. And you're concerned that the source should not be disclosed. That's what I heard. Ms. Leung saying, I thank Chairman, thank you, and thank you to the groups and individuals attending today's hearing. Well, I've got the impression from the groups. They are the groups that over a very long period of time they oppose the government. why these provisions have stimulated these groups. But there are many groups in Hong Kong, whether political groups or non-political groups. There are many of them. But today there are not too many groups present today. As for the remaining groups, they are in society, they're living in society, and they also come across this ordinance. These many groups, they are working for the interests of the community at large, and therefore they are not concerned about the adverse impacts on them. Will the administration make use of the media, including the public sector media, to explain to the public more frequently? And that is the important core value. If you have not done anything wrong, you don't need to be worried about people knocking on your door in the middle of the night. If you have any worry, it is because you have done something which will cause you to step on a landmine. The landmine is to protect public interests. The second question is for the groups. So far, with regard to this ordinance, what evidence is there that people's rights and also express freedom of press freedom, or freedom of information, freedom of expression has been restricted or has been threatened? If the officials are interested, they may also answer my question. Well, let me ask the groups to answer the question. Miss Yu. I thank Ms. Seng for his question. Now, in the kidnap case, I think you asked a question. You asked about public safety and Internet. I heard that last night a serious case happened. Some culprits escaped. There was a lot of information being communicated on the Internet. Information in the Internet might let the culprits know the deployment of the police. And the Security Bureau said there was a challenge. We see that the law enforcement agencies and the government officials have a different view with us, with our groups, and therefore we come to respond. As for journalist material, the JA can supplement. In 2012, a LEA breached the rule and intercepted journalistic material, and some sources supposed to be anonymous was disclosed. You can refer to the news reports, and that is the evidence that we are concerned about the protection of journalistic material. I saw Ms. Zhang's hand. I give the floor to Ms. Zhang first. Please go on. Ms. Zhang said that if you have not done anything wrong, you don't need to be worried. We are sitting here because in this council, we are to discuss legislation, the legislative process, and the need for legislation. If everybody has your mindset, then you don't need a law at all. We need a law because people think differently and people does something wrong, and therefore. Now, please answer the question. And please do not conduct any discussion on values. Well, that is expression of values here. Then why don't you stop him? Why didn't you stop him? You say you shouldn't discuss any values. Now, if she answered the question, she should answer the question asked by members. I don't whether they mentioned the umbrella movement. I didn't stop them. Now, if a member has asked a question, if the group has an answer, wants to answer the question, then the group should address the question. Well, then I have to say that now he just said that minority interest doesn't need to be careful. You belong to a minority. You better reflect on yourself whether you have done anything wrong or not. That is to blame the victim. We have seen that many times before in this council. They just blame the victim. The majority of people support you pocket it first, and then you have to pocket it. In the future, the rich and powerful will use the majority to bully the minority, to suppress the minority. Now, go back to the question. Concerning law enforcement, you need to do something secretly or covertly. I understand that. I support the need for the ICSO, but in certain provisions, there are issues which we want you to explain. I will not ask you now. Now, metadata. My question is whether metadata is included. We're talking about the provision. We're not talking about the law enforcement needs. Law enforcement need is not the ground for exemption. I want to follow up on a point raised by Mr. James Ho. Is about the ISPs. They are really suffering from a lot of problems. The police comes with a warrant. They even don't spell out which ordinance. Therefore, a few years ago, I asked the C&E department and the police to sit together and try to draw up some code of practice or guidelines. In fact, in a case, they took away a whole hard disk. Just part of the information in a hard disk includes the information they want to investigate. And now they don't use they take away the whole hard disk, but they also copy information from the hard disk, but they may copy information of the people that are of the information of people who are not involved in the case. They are trying to detect, and that's a problem. My question is about a question raised by the data frontline or keyboard frontline. Now they said that public security would not be the basis for covert surveillance in order to achieve political objectives. I want to ask the groups, according to your opinion, with regard to public security, is the safeguard adequate? Is the definition of public security adequate? Is the definition of political objective adequate? And is there any activity which is trying to collect information for political objective? Do you want to designate anyone to answer your question? No. Two from the groups on to answer the question. First, Mr. Law. Many participate in political activities are worried about these problems or questions. They feel that their communications are interfered with. Now, certain pieces of information is only known within a small number within their group. Yet such information is known by the police. So they are concerned that the government is conducting political monitoring or surveillance. Now, if you look at the code of practice, they said that unless it is is for advocacy, expression of democracy, unless they are they have adopted the means of violence. They should not be regarded as threatening public security. And violence does not include minor scuffles or minor vandalism. Yet, during the umbrella movement, if you just hold an umbrella, if you just put up a face mask, you are suspected to have committed a crime by the police. The definition of violence by the police has been exaggerated without limits. And according to the provision, if there is any violence, then you can be arrested. But the definition of violence adopted by the police has changed substantially. Mr. Wing. Now, to combat serious crime and for public security, interception is conducted. There is no objection. Now, there are quite a lot of imagination. They are concerned about journalistic material, and also other thing, privacy. Now, the CNE department, the ICAC, and the police are the LEAs that are authorized to do interception. They have to get approval or authorization from panel judges, and they are also subject to the monitoring of the commissioner for ICS. They are concerned about loopholes. They are concerned whether that is real monitoring. When it comes to standards, we need to have some measurement, some comparison. I don't know whether the administration has compared our mechanism with the so-called European and North American advanced democratic countries. As for these bodies, do they conduct any interception of communication? Do they have any regulation of interception of communication? And do they need to have post-surveillance monitoring? Well, let me remind you that you better discuss with the groups. Well, from time to time, we do refer to the practice of overseas countries.
For visible information in the public domain, I think our mechanism is comparable to that of overseas countries. Sometimes we are even stronger. Say, for example, in the case of journalistic material, usually they don't have an express provision, and they don't even have it included in the code of practice, say in the case of Australia, but we do have some provisions. We talk about what sort of a report is required and how the authorization can be continued. Now we are saying that the commissioner should be given the power to come across and examine the protected products. I think I'm quite sure that this is absent in overseas corresponding laws. So if the bill is to be enacted, it means that Hong Kong will be in a better position than elsewhere in the world. Mr. Wing. I hope the government will give more information to the deputations and the legislative members. Otherwise, we will be sort of getting over-worried, and it would not be good for us. Well, I will say this. Just now, the government has referred to some reference material. Can you not sort of put them together, like the case of the USA, Europe, etc.? We've been talking about learning from the experience of the USA and Europe. Let's compare how we've been performing. Say, for example, whether we are stricter, whether we are more relaxed, and whether there are loopholes. In this way, we can ease the mind of the deputations. Let me say this again. We are here mainly to exchange views with the deputations. And the Bills Committee's work will continue, like we have asked the government for further information. Such can be followed up later. James Toh, Sin Chung Kai, Tony Che would like to ask questions in the second round, and Charles Mock would like to ask questions in the third round. If you haven't got other questions, I think it should be more or less about it. And please mainly be asking deputations questions. Just now, they haven't asked for a reply from any specific deputation, so I haven't given you the floor. It doesn't matter. If you are being named, then I will give the floor to you. This is our usual practice of holding public hearings, at least on my part. James Toh. I'm not sure if the government is willing to talk about this. So far, the government has been very vague, like under the ICSO, as well as the bill. What about WhatsApp and Line? I think all of us are using this kind of communication service. Will it be applicable or not, and how and to what extent? I think it's important to explain this to the public so that we know where we stand. There are also members behind me who have been saying that there has been a lot of misunderstanding. Maybe it is not a question of misunderstanding, and I give the time to the officials to tell us about the instant messaging service like WhatsApp and Line, which part will be susceptible to interception and which not. And please also come back with a detailed paper in writing. DS. Thank you, Mr. James Toh, for this question. Under the ordinance, we need to understand a few important definitions before we can address the question of social media, including WhatsApp, that is, whether it meets the definitions requirement, and so will be covered. Sorry, I can't quite hear her. I put on the earpiece and still I couldn't hear her. Please speak closer to the mic. Sorry, let me say this once again. Any social media or applications, since they are sort of being changed all the time and very rapidly, not that we're dodging the questions, but then the ordinance itself attaches a lot of importance in relation to the fact that anything disclosed should not compromise the ability of the LEAs in combating crime, and we don't want to allow the criminals to abuse this. Even for the commissioners report to the CE may also take out some of the contents of the report before it is made public. So please bear with me, and I can only give general comments. No, I'm not talking about individual or specific cases like a case of kidnapping. I'm moving on to the specifics. Let me talk about WhatsApp. Prepare a detailed paper. What within WhatsApp can be intercepted and what not. Today, millions of people are using this. If you say that it's sensitive and so can only give a general comment, don't be so emotional. It is a very serious point. You still have to give the floor and time to her, but she is refusing to answer. Let her answer first before you give a comment. She hasn't finished. Deputy Secretary. Mr. Chairman. For the applications of social media, I think we need to look at two definitions. That is, what can be intercepted, and also we have to look at the definition for telecommunications. An act of interception, including what Mr. James Toh has referred to. Well, if it is I mean, if it meets the definition of interception because it is not being examined by the person sending the message or receiving the message. And then we can also look at the definition for telecommunication, which is KWAN 106, section 26. That is any transmission, emission, or reception of communications by means of guided or unguided electromagnetic energy, or both. So if you intercept communication meeting such a requirement, meeting such a definition, then you will be covered. Of course, I'll be happy to produce a written paper. Last time Mr. Mok asked this question, we still owe him a written reply. Now, after sending out a WhatsApp message, and you go to the server of WhatsApp and try to restore it, will it be regarded as metadata? I think just now it has been said. No, I want it to come from the government. Deputy Secretary, I don't think we can restore it or reconstruct it. It is really what is being intercepted in the process of transmission. When it has been received, then it is something else outside the scope. In other words, they can go to search the server of WhatsApp and have it restored, then it will not be caught in this ordinance. Just now she talked about applying for a warrant. Give us a paper and tell us about the criteria covering a warrant. Give us the details and let's compare the different criteria here. Sin Chung Kai, I'm on the same point. I don't need an answer from the government because the government will give us a paper. Now, a question for the deputations. My understanding is simple. So it's an interception of communication. But then if the LEA is to go to the cloud to get it, then it is different. If they are technically capable enough, they can go there directly to get it. So deputations do think that we need to expand the scope so as to cover the innovative forms of communications. It is a matter of a different technique being used to intercept. So when you get the when you want to intercept the communication, either you do it in the process or you go to the cloud to get it. So would you like to expand the scope to cover the cloud as well? Who would like to give an answer? – 30 seconds each. Ms. Ng, Mr. Ng, Ms. Wong, Ms. Yu. Five minutes only. I'm letting them have 30 seconds each. I can queue up 5 times. I just want to explain why I'm doing this. And then Mr. Law and Ms. Zhang. And Ms. Ng first. Of course, I'm against further expansion of the scope. Even as of now, I find the scope too extensive. Let me come back to the ordinance. The ordinance has been in place for quite a period of time. Just now, Leung Sing has been most disrespectful. He was very hostile. Does he have any claims? Does it mean that if I've got nothing to hide, I should welcome LEA to come anytime to my home and to carry out a search? Mr. Ng, Article 30 of the Basic Law protects citizens. so that we are entitled to private communication. Now, I think for this ordinance, this is to facilitate the LEA in combating crime. Article 30 of the Basic Law says that, first of all, we must protect the rights of the public. Now, you try to expand the powers of the LEA. In other words, it is a matter of encroaching upon human rights. Ms. Wong, I still cannot get a justification. I still cannot understand clearly what is projected and what is not. Ms. Lee seems to say that content of WhatsApp messages, if justified, can be intercepted. I may have some intimate messages with my boyfriend. You might suspect that I broke the law, and so you will also want to get hold of such private conversation. I think Mr. Leung Sing was trying to challenge our bottom line. He said that we have a clear conscience. Does it mean that I haven't broken the law? I should strip off all my clothes and let you have a body search of me? Ms. Yu, having get the answer from Ms. Lee, I'm less worried, because she was saying that communication on the internet will be covered. Now, when we talk about expanding the scope, are you expanding the scope that the LEAs may intercept communications, or are you expanding the scope of monitoring? Let me explain my question. Currently, the law doesn't cover what I referred to, so I'm not sure what I should assume. Will the government be doing what it wants? We are now authorizing the commissioner to monitor the LEAs. Currently, I don't know if the LEAs have got a warrant or if they will just hack into the cloud and try to retrieve the information. Next, Mr. Shum. I think, first of all, we need to find out why we have introduced this piece of legislation. That's for the protection of privacy. Loopholes have been identified, and I fail to see why 8 years have passed and you're still not trying to expand the scope. And then some members spoke, and I found it regrettable. Now, citizens come here to express their views. I think the LegCo should respect the views of people who may disagree with you. Mr. Long, as to the right to be protected, it is a matter of effective protection instead of merely some protection. In the process of communication, if you say that at the time of transmission it will be monitored, but then if it is a matter of retrieving it from the cloud, then it is not protected, then it is not right. It is indiscriminate interference.
Ms. Chung, I agree with Mr. Sham. This legislation is to protect people's privacy. If it is those that if the information is not covered, if the information is privacy, then it should be regulated. Or this ordinance should regulate such covert surveillance on such information. The Deputy Secretary doesn't want to disclose too much about the operation of the LEAs, what they can do, what they cannot do. She doesn't need to disclose the specifics, but this is about the law. Mr. Tony Che. Several representatives commented on the power to obtain interception by interception or covert surveillance. If there is any misuse of information or abuse of power, there is only internal disciplinary action against the officers. I've heard that point several times from the groups. I hope the administration can explain whether this is really the situation. There is only internal disciplinary action against the officers for their non-compliance. Apart from that, are there other ways to penalize such officers? Internal disciplinary action is just one of the ways of handling the non-compliant officers. And the disciplined forces have laws for conducting disciplinary action. And according to their ranks, the higher, more senior officers are subject to disciplinary rules, which are backed up by legislation. And also the commissioner can also make recommendations in respect of the non-compliance and how to deal with the officers. And then the head of the LEA will have to consider the view of the commissioner. And if the case is serious, the officer may be subject to the punishment under misconduct in public office. Say if information is used to conduct improper or even improper activities or even commit unlawful acts, can the administration only deal with him through internal disciplinary action? This is what I heard so far. Well, the situation can be very serious. It can be a criminal offense under the criminal ordinance, crimes ordinance, Cap 161. And if there is evidence, conduct in public office can lead to serious consequences, such as imprisonment. Mr. Charles Mock and Mr. James Toh want to have the third round. Some members behave very strangely today. They refer to international standards. When it comes to universal suffrage, they don't refer to international standards, and they don't know international standard, or they only know international standard partially. They look at the Snowden case, and there is the FISA Act, Foreign Intelligence Surveillance Act in 1978, and they have been changing that. And that includes physical searches, unlike the narrow scope of our ordinance. The problem with the United States is that the government doesn't follow. CIA, NSA don't comply with the law. The judges are really angry. It is about the enforcement. This is an enforcement problem. They don't know the distinction between the executive and the legislature. That's the standard of the members of this council. Now, Snowden criticizes the U.S. government because the U.S. government doesn't follow the law. Snowden doesn't say the U.S. law is not adequate. It's that the U.S. government doesn't follow the law. That's the same situation in Hong Kong. The government doesn't comply with the law. You give the power to the government, and then for convenience sake, they just try to get around the law. They sometimes they just don't follow the law. So the legislators should monitor the government. Now, there is a reference to international standards. So I give you the time to speak on international standard. Who would like to speak too? Mr. Law. With regard to international standard, doesn't mean that which country is doing what. We need to refer to the international covenants. The practice in other countries are just for reference. The most important reference is the ICCPR. Don't use countries which adopt to poor practices as a reference. Don't use countries which breach their own laws. Don't use governments which they breach their own laws as a reference. We are concerned about the content. We are concerned about the protection of metadata. If metadata is not protected, then privacy is not protected. Although this ordinance is about interception of communication, if there are no related protection then people's rights are infringed. The law should be amended to protect privacy and also the products of communication. Ms. Chiang, I agree with Mr. Law. International standard can be a reference. You cannot say that if they adopt your same position, therefore you use them as a reference. If they adopt a different position from you, then you say we don't take that as a reference. You cannot be choosy. The Secretary said that the consequence of breach can be very serious. Now, if that's the case, why you provide so much room to maneuver for the heads of LEAs to maneuver? Why can't you put it down clearly in the law so that everybody can follow, so that there will be there won't be such a big room for them to maneuver? Three more. Well, maybe since it's the last round, let them finish. Ms. Wong first. The Deputy Secretary said that there is internal disciplinary action. But I don't understand why some blatant offenses, some blatant mistakes have not led to anybody subject to internal disciplinary. Let the example, 7 policemen beating up a person in a dark corner. There is no internal disciplinary action. Nobody will trust you. How can you convince us that the amendment bill is something that can be trusted? Listen. This is also about disciplinary action. We cannot see any disciplinary action taken. And if one is subject to disciplinary action, one still can receive pay every month. Now you say there is misconduct in public office. How many such cases, how many officers have been handled by this? According to Mr. Liangxing's logic, why can't there be an offense for the officers created? Our concern is similar. With regard to the ICSO, since 2006 now, every year, there were LEAs who didn't comply. They were just given verbal warning, and that's the end of the story. I really want to know how many cases have been dealt with. If they if they are non-compliant, what actions have been taken? What punishments have been given out? Can information be provided? James Hill. Let me put forward an answer, which is, let me preempt the administration by putting forward an answer. Why interception of communication is needed? When A and B are online, say they are speaking on the phone, something just disappeared in a second. The telephone company doesn't make any voice record of the content of the communication. There is only a record of who called whom for how long. For example, IDD, you need to charge. Now let me turn to WhatsApp. Everybody uses this. If the message has gone from A to B via the server, and the server has a record, if this is related to crime, or if it is related to public security, the message has been stored, that becomes a piece of evidence. If you want to search the evidence of the offense, then there is a uniform standard, whether it is the record book of Godber on how much money he received, to the information in the server which can be recovered. Why you single out this? What's the theoretical justification? This is rather deep. I have asked myself this question. I've been thinking over this. The administration has to answer this. You cannot say that they are the same. The record book or account book of Godber is different from the information in the server. There is something which cannot be brought before the court as evidence. Now, say, for example, deliver the goods. This is the piece of information in the WhatsApp. How can that be brought before the court? If you're interested, you may give me a written reply. If you don't have an instant response, you can give your view to Mr. To after the meeting. All right. Finally, I asked the administration to give a general reply. I still have some time. I also request the administration, they shouldn't just give a simple official answer. Now, this is a conversation. If it is interception of communication, you will not use it. You cannot bring it before the court. Why? You treat it as evidence of crime and search for it. This is intelligence. This is not evidence for the crime which is to be brought before the court. You get a warrant to search for evidence of crime. Well, in fact, Mr. Wong will say they just go to the ISP, they don't need a warrant, and the ISP will give the information. Now, if that is the case, you search something, you try to recover a conversation, can you do it as in a way as collecting evidence of a crime? That may be subject to JR. People can get legally to do it. Can the administration answer us? How do you look at this issue?
Yes, maybe the government can give an overall reply. Deputy Secretary. Thank you, Mr. Chairman. We have heard the views at the meeting. There are a number of important issues that I want to take this opportunity to clarify. Among the deputations at today's public hearing, many of them may not be too clear about the objective of the ordinance. Let me say this. All along for the ICSO, as far as its objective and its scope is concerned, I think we'd like to ensure that the specified LEAs will have their interception of communications and surveillance carried out just for the purpose of combating serious crime and protecting public security. And therefore, we have got quite an elaborate system, and there are many stringent requirements regulating such actions so that the LEAs must follow the procedures, and panel judges will sort of be operating like a court, and you have to put in affidavit before you can get your approval. And then the panel judge will give approval, and there may be conditions attached. I think the objective is very clear. We are binding the public officers. It won't apply to non-public officers. It won't apply to non-government organizations. So we have to make it clear that as far as the scope of the ordinance is concerned, the exercise of amending the ordinance as stated in the bill will not see the scope expanded to cover non-public officers. Earlier on, there was also communication or discussion on the following point. Despite the elaborate system, when the ordinance is being invoked, it seems that it has been quite messy, and then the LEAs have been trying to be dishonest and have only followed the rule partially. I just want to say that authorizations granted by the panel judges and whether the authorization has been renewed after consideration, etc. Section 3 is most important because it is very clear that there is a definition for serious crime. So when it comes to the interception of communication, we are talking about serious crime, in other words, imprisonment of 7 years or more. And then political monitoring does not come into play, because when we talk about threatening public security, it must be something specific. And in fact, there was detailed discussion in the LegCo for this on this point. At the time, we were talking about something very serious, something that would be similar to terrorist acts affecting Hong Kong as a whole, or human trafficking. So public security being threatened in a very serious way. I recall that during the resumption of the second reading debate, the then S4S has pledged that the government would not be on the ground of public security carry out political monitoring, and again the ordinance would not be invoked to allow the government to engage in such activities. The ordinance as well as the code of practice have also clarified the definition of violence. Minor scuffles or minor vandalism will not be covered, and of course anything beyond this would require the panel judge agreement that is something serious before he will grant approval. As I have said last time, other than being clear about the definition, for you to invoke the ordinance, there is also the question of proportionality and necessity. In other words, the LEA must satisfy the panel judge that there is no other means to do so to achieve the purpose, and then the ordinance can be invoked. And for you to invoke the law, you have to give an account, that is, how you can lower the degree of intrusion into the privacy of the subject. And that brings me to another area, that is protection of privacy. A lot of the provisions of the ordinance are such that the purpose of the operation and the degree of intrusion should be balanced. The purpose of the operation cannot be achieved by other less intrusive means. The panel judge has to be satisfied on this threshold. When we designed the ordinance, and for the 9 years of implementing the ordinance, we have always been following the provisions closely. For public security, as to the definition and how it should be amended, etc., I don't think it is within the scope of the bill. Of course, we will be willing to listen to the views of the public and the deputations. We do take the matter seriously, that is, how the ordinance can be implemented in a way acceptable to the public. So I hope I have made myself clear and have clarified the position when we first designed the ordinance, certain things were in mind, and I've sort of remind you of that. And time and again, the government has guaranteed that the law will not be abused to achieve political motives or to carry out political monitoring. Of course, another point was raised. That is how privacy can be protected. Just now, I have already briefly touched upon it. Under the ordinance, we have got a number of provisions. The ordinance itself empowers the commissioner to cover quite a wide area of work, and for the commissioner to examine the work of the LEAs. I think every week the LEA has to report to the commissioner as to the number of activities carried out under the ordinance. The commissioner regularly and randomly can go to the LEA's office to carry out an examination. Just now, some organizations have talked about their concern about the devices. Well, I just want to say that the commissioner's examination will also cover the storing and record keeping of the devices, as well as the log of the use of the devices. And the commissioner will try to match the records. The commissioner will not just listen to the LEA's report. The commissioner will also match the records with the conditions imposed by panel judges. Panel judges are all incumbent judges, while the commissioner is a former judge. The design is such that we are trying to get the most credible person, someone who is fair and just, to fill the post of the commissioner. If you still cannot believe in such a setup, I think it will be difficult for us to have another overseeing organization above him. I have jotted down a point. It's been wondered whether the commissioner's power is inadequate. I think the ordinance has made it clear about the core functions and duties of the commissioner. The commissioner has to submit an annual report to the CE. The report has to contain a number of mandatory elements. It is provided for under the ordinance. And the commissioner can come up with recommendations for the heads of the LEAs. And the annual report is presented to the LegCo every year. And on the same day, he will be meeting with the media. I understand that LegCo members have been very interested. LegCo members have been attending the media session and have conversations with the commissioner. You may very well think that it is inadequate or want to further enhance the transparency. If you do have views on such matters, we will have an open mind to listen to you and will refer your views to the commissioner. However, I think we have already done our best to try to satisfy you. But don't forget that the ordinance has made it clear. Even for the annual report, the CE will take a look to see whether there is anything sensitive, to see if anything would jeopardize detection of crime, and whether something will be stated evidently with the result of reviewing the investigation capacity of the LEA to the criminals. So I hope you can understand this point. It is only in very few cases that we are not able to make a full disclosure of everything. Of course, between the right to know on the part of the LegCo and our work, the two must be balanced. But I can assure you that what has been requested from you by you will be carried out by will be adhered to. Will be giving you something in writing. Just now, some deputations have said that the safeguards are inadequate. I've said that the intrusion into privacy should be kept to the minimum. We need to strike a balance. We don't want privacy to be intruded by too much. Secondly, I think everybody will be concerned as to whether the LEAs will be empowered to intercept our private conversation, whether it will be disclosed, whether the powers will be abused. Well, it is exactly that the bill seeks members' support to give an express provision to the Commissioner so that he can listen to any protected products. In the past, the Commissioner was not able to do so because he's worried that in the absence of an express provision, and if he's to do it, then it may jeopardize the LPP. So he would like to get the power. In this way, it means that there will be a stronger deterrent effect on the LEAs. And then LEAs don't have to wait for a mistake to be exposed before they become more careful. We also hope that by implementing this proposal, your worries can be removed, and then by having a stronger mechanism, there will be a stronger deterrent effect, and LEAs will not be abusing their powers. I want to say that the current proposal, of course, we haven't got the Privacy Commissioner for personal data here. We have consulted his views, and he's in support of the bill. And for the code of practice, and he has some suggestions to ask for more details to be given. We will follow suit. After the bill has been enacted, the code of practice will be amended. The code of practice under Section 63 can be revised by the S4S. We did so a number of times in the past, and we have come to the LegCo, and the code of practice will be gazetted, so you don't need to worry about the transparency. So I think the COP will be enhanced as a result of your concerns. So we are going to take this step, and as the chair has said, there are still many opportunities to discuss the matter and for you to give your comments.
Last but not the least, I think it's important, and therefore I put it here. It's about journalistic material. This is a major concern which I heard this morning. With regard to journalistic material, the laws in Hong Kong, in particular under this ordinance, there is quite a lot of protection under the law. There is a definition of journalistic material. You can refer to KWAN. Why a definition is given? It's because in Section 3, the LEA, in making an application for ICS, will have to conduct an assessment in the affidavit to express in the affidavit or in the application whether an assessment on journalistic material has to be made. And if he has not done that, then he will be criticized by the judge. Now, if they make an assessment on the possibility of journalistic material, the judge will look at that, and the panel judges can also impose conditions if approval is given. Of course, the panel judges can also refuse the application. The panel judges are very experienced in this regard. Well, if the assessment is that there is no journalistic material, but in the interception process, in the hearing process, there is something which looks like journalistic material, then the LEA will have to report to the judge. The judge will then consider anew whether the continuing interception is still in line with Section 3, which is about serious crimes, proportionality, public security, necessity, so on and so forth. The judge will consider whether approval will be given to continue the interception. As for cases, in 2009, 9 to 2012, in the annual report, reference is made to cases in relation to journalistic material. We've studied the cases, because we received the petitions. The Commissioner looked into those cases and didn't find any irregularity or non-compliance. Now, he made a note. He didn't hear the protected product. If he has heard the protected product, would his view be different? Or even if his view is the same, the justification may be maybe stronger. Therefore, we propose to change the law and let the Commissioner to listen to the protected products, including cases involving journalistic material, so that he can make an informed decision whether there is any irregularity, whether there is any non-compliance, and what measures should be recommended. And let me also point out that it's not just the ordinance which protects journalistic material. In fact, the COP in 2011, upon the request of the then Commissioner, we changed paragraph 65, which specifies that all express authorization involving journalistic material has to be approved by the panel judges. Now, if the infringement is very low, then designated officer appointed by the LEA, head of LEA, can give the approval. But Section 65 says that once the action may involve journalistic material, then you have to go to the highest level. You have to go to panel judges to seek authorization. This provides an additional layer of protection to journalistic material. This is to clarify this with the groups. Some groups ask about the non-compliance. What are the numbers of the non-compliance and how they handled? In so many years of operation, 60 public officers were penalized. The highest level of penalty was a warning, written warning, if further non-compliance will lead to dismissal. Serious reprimand is another level of punishment. There are serious consequences. There will be no promotion for so many years. Even if you've got good performances, because of this black mark or blemish, you'll be not promoted for so many years. In the civil service, the disciplinary action is according to the law. There is a discipline force, discipline action ordinance, something like that. They have to go through discipline hearing. The maximum penalty is dismissal. If the public officer is subject to disciplinary action because of non-compliance, and if that act is also an offense, then the criminal offense will go first. It will have to be brought before the court, and then depending on the outcome of the court, then there will be disciplinary action. The judicial process goes first. That's the arrangement by and large. Mr. To is right, and his concern is also important. With regard to interception of communication, Mr. To said things have changed. It's not just voice communication, and there are records. Mr. To fully understands the ordinance and is one of the designers of the ordinance. As for TI, the information obtained through TI is for further investigation. It cannot be used as evidence to be brought before the court. Say, for example, if there is a crime group, at the start, you investigate 1 or 2 people, the group may be very big and complicated. How do you know how many people are involved? How can you know how big the group is? How can you know who have committed what crimes? In the investigation process, we may need to resort to the means we mentioned earlier. The information obtained is for further investigation. That's the design of the ordinance, and there is no change in the ordinance, though the means of communication may have changed. The information members ask for will we will fully consider the question, and then we will give a written reply, and members may look into that further. As said by the chairman, we still have a lot of opportunities to discuss such issues. Finally, on the regulation of non-officials, it is outside the scope of this ordinance. The LRC a few years ago issued a number of reports on non-public, non-officials, non-public officers conducting interception of communications or covert surveillance. The issue is given to the CMAB for further study. As for whether criminal offences should be created, if there is any non-compliance on the part of the public officers, the regulation is very long and complicated, detailed in the ordinance. There is disciplinary action, there can be criminal sanction. We think the present arrangement is adequate. We will look into how the CMAB respond to the reports of the LRC before we give any specific reply. Thank you for your indulgence. I'm a bit long-winded. I just try my best to respond, address your concerns. Thank you. Thank you for spending 30 minutes on responding to the groups. I'd like to thank the groups and individuals for attending our meeting and for giving us your views. Thank you once again. You may now leave. Let us go back to our own meeting. Mr. James Ho. I think this is related. I hope the administration and also the groups can give us their written views with regard to the product of interception. Now you search the WhatsApp. You apply for a warrant for collecting evidence, and you get the information and then put it in the criminal intelligence system, and you can keep it forever. The administration said it has reviewed this. You may just say somebody has made a remark, say the CE has said something wrong, say bomb him or move him. Then you will say that is A trying to incite B to take certain violent action. They intend to assassinate the CE. You put it in your criminal intelligence record. In the future, You can say that intelligence has shown that A has said this, he has certain inclination, or he suggests to assassinate the CE, and then you bring this to the attention of the panel judges when you apply for interception. Now, what level of how trustworthy is this? I'll say the comment is that he has this intention to assassinate the CE. How trustworthy is this? When you bring it before the judge, you can bring this in message before the judge. I think this is very dangerous because this so-called criminal investigation intelligence or criminal intelligence system is outside the scope of this ordinance. Now, have you completed the review and there is no change? The groups may now leave. Concerning Mr. To's question, the administration has heard that. The Bills Committee will continue to discuss the topics one by one. Thank you once again. Now, when the officials give written replies to members, will those replies be made known to the public? Yes, I believe you can get it in the internet. I believe you know the channels. You just follow the practice of this committee. Thank you. At the next meeting, 11th of May, Monday, 8:30 a.m. A member at the previous meeting proposed to invite the previous commissioner for ICS, Justice Wu, to the meeting. Justice Wu has replied and he rejected the invitation. So we may not be able to have him to discuss with us. Mr. James To, concerning I suggest we invite the experts of instant communication applications to discuss with us so that we understand what falls within the remit of interception communication and what falls outside the remit of interception. I hope we can consider inviting such experts to come to discuss with us. Okay, we've had this view. Okay. The meetings are adjourned. Thank you very much.